Yeah, thank you. Systems are on. Oh, yeah, I hear reverberation from the microphone. I see by the clock on the wall it's 9:03, and the reason that we're not starting at 9 is my fault, me and the train. Today is March 23rd, 2023, and we are located in the St. Croix County Government Center, room 1284, the boardroom. This is the time and place that was announced for the March meeting of the St. Croix County Zoning Board of Adjustment. Therefore, I'm calling the meeting to order. My name is Buck Malick. I'm the chair, and I'm from the town of Hudson. I'll ask the other board members and the staff who are here to introduce themselves.
Dave Peterson, citizen member, town of Kinnickinnick.
Joe Miller, citizen member, town of Hammond.
Greg Teljohn, St. Croix County Supervisor, District 14, Aaron Prairie, and Richmond Township, and a little bit of Warren.
Dave Nickham, town of Baldwin, citizen member.
Mike Wozniak, Land Use Administrator in the Community Development Department.
I'll state for the record that I believe this meeting was properly noticed and published under the open meeting law and the law that pertains to zoning conditional uses such as the one we're about to deal with today. If anybody has reason to object to the notice, please speak up at this time. Hearing no objection, we will deem it to all have been done in proper order. We have no minutes today. We will proceed directly to the one hearing that we have on the agenda for today, and Mr. Wozniak will be making the staff presentation. Go ahead.
Very good. Good morning, Board of Adjustment members. And I would just note that I think you were informed, but we're not expecting the applicant to be present. They indicated they were out of town. So just for your reference, we'll just get this presentation size so it can fit on the screen.
Let me just state there's no one else in the room either. Nevertheless, for the sake of the record, we will make a record, and so we'll ask Mr. Wozniak to proceed as though there were people here. After all, we represent people who often are not in the room, the public.
Very good. You have on your agenda consideration of a conditional use permit application from Tim and Kristen Reeser for their property at 280 Cove Road in the town of Troy. This request has to do with the conditional use permit required in the Lower St. Croix Riverway Overlay District. They're desiring to construct some stairs to provide access from their driveway down to the front of their home. The board has been provided with a copy of the staff report that I'm going through, and also a notice of violation letter and affidavit of service that we had done in relation to this some activity that preceded this request, and also a copy of the conditional use permit application submitted by the Reesers. And I would note that we had indicated we hadn't received comment from the Wisconsin DNR. I would note that I just spoke with Mike Wentholz with the DNR yesterday, and we received an email that basically there's no objection to the stairs. The only indication was just comply with the provisions in our ordinance that they should comply. So just for the record, I'll note that. The property, the board should be familiar with this. You considered variance, I believe three variances, 3 or 4, and a conditional use permit request last fall. And those requests were denied at a September 22nd Board of Adjustment meeting again in 2022. The property is about a half-acre parcel, and I just note there's a couple other properties that are served by the driveway that comes off of Cove Road and serves the Reesers lot. Some of the photos on this slide would look familiar. Just a little background for you. The home sits about 14 feet below the driveway garage in terms of elevation, and it does it would be considered slope preservation zone, that slope that runs down to the home. And there are stairs, there were stairs, and there were also some temporary stairs, which I'll get to, constructed, that that run from essentially from the garage or driveway down to the front of the home. These stairs you're seeing in this photo were existing and were in place when you considered those applications last fall. Just another slide, just some other background on the property that I won't spend a lot of time with, but there was previous work that was properly permitted, couple areas of riprap and some stairs from the back of the home down the slope towards the river. And the current owners, the Reesers, have extensively remodeled the home inside and out as well. Just want to talk about the violation that kind of preceded this submittal of this application by the Reesers. Following the board action last fall, the Reesers proceeded to have some stairs constructed, as you can see in this photo, and it was clearly communicated both prior to the board action last fall and at the board meeting as well that they would have the option of applying for a conditional use permit for stairs or even a lift to safely get from the garage driveway down to the home. And they proceeded without doing that, and that was observed in early October, and they were informed of the violation, and typically there is a double fee requirement for after the fact permits, and we're interacting with the Reesers on that issue because they paid the normal application fee, but not the double fee, essentially the extra amount required for after the fact. The applicants were informed also they could, if they felt they shouldn't be subjected to the double fee, that's a staff administrative decision to implement our fee schedule, the requirements on our fee schedule. They had the option to appeal to the Board of Adjustment. Of course, there's an application fee required with that as well, and they chose not to appeal to the board, at least not as of yet. This is just a timeline of events that document what I just briefed you on, and again, your denial of their earlier request to tear down the garage and construct an attached garage onto the home occurred on September 22nd of last year. We became aware of the violation October 11th, sent a letter of violation. We proceeded to work with the applicants on what they would need to do to obtain conformance. They had some difficulty getting some plans drawn up, so we actually extended a deadline we had given them to address the issue, and gave them till February 6th to apply for a conditional use permit. They proceeded to apply, and that's what you're considering today is their conditional use permit request for the stairs. This site plan indicates in blue where the location of the stairs will be. This is essentially the same place the stairs you saw in the first photo I showed that were existing on the property are located, and where they place those temporary wooden stairs as well, basically essentially the same location. What they're proposing is to construct a new set of stairs out of metal and anchor them on footings as well. These are some drawings, plans and schematics of the proposed stairs. Get a sense of what they'll look like. They're kind of longer treads and than what you might normally see with stairs, and I don't know if it's basically to negotiate the slope more easily, but essentially with the stairs, they have to comply with applicable building code requirements that are administered by the town. I would note that we hadn't received any comments from the town of Troy, and like I said, we just received a comment with really no objections, just indicating that we should hold the Reesers to the requirements spelled out in the applicable provision of our Riverway Overlay Ordinance. In terms of your action, you have the options of approving the request, denying the request, or asking for more information if you feel necessary. And you should stipulate the findings to support your actions, whatever it may be. Now, I'd note that under findings, I won't go through the information about the property, but I would note on here that the project is subject to stairway standards in section 17.36 H12 of the Riverway Overlay Ordinance. And
While you're there, let me just confirm that the Riverway Ordinance has limits on landings on stairs, does it not?
correct.
And those, that wooden structure that you discovered on your visit would not meet those requirements, would it?
I believe it would not. I think you're correct on that. And
They're too large and they're too close together, the
Correct.
landings, that is.
correct.
All right, got it.
Yeah, I appreciate that being pointed out. You know, the way the Reesers described this is they felt they had to do something temporary for safety, but the county doesn't really have any provisions for temporary structures. And so, you know, they would have needed something approved that was compliant with the applicable standards. Getting back down to findings, I just note that we've referenced the applicable requirements in the findings of fact under paragraph 7, and I won't read through each of these. I know you've seen them before, but essentially they have to conform with these requirements. I would note that regarding vegetation, we're not anticipating they're going to disturb a whole lot of area for this, but we have included some recommendations to address establishing proper cover and avoiding erosion issues as well. And I'll get to that in a moment. And I would note under our paragraph 8 and under findings that there are provisions on width and landing size as well that we reference here in this section of the findings, and also that we note that a plan shall be submitted to the zoning administrator and certified by a registered professional engineer or architect showing that the lift, this should read, stairs are securely anchored to prevent them from shifting and from causing erosion. Because they are being constructed on a steep slope and they're being anchored with footings, we want to make sure that's properly done. I would note further under findings that that we note in terms of is the project in the spirit and intent of the regulations. Construction of a stairway is a use that's allowed by conditional use permit approval in the slope preservation area, and there does not, this would not violate the spirit and intent. The permit approval would not be contrary to the public health or safety as long as the standards are conformed to. They're spelled out in the ordinance. And also I note that the results of the project are pretty modest. This should not be visible from the river, and really the main issue we have is they'll have to confirm that they're complying with the earth tone colors on the color palette that's required within the Riverway Overlay District. And I'd go on to just address our staff recommendation on this. Based on the findings of fact and conclusions of law, staff recommend approval of the conditional use permit to construct the stairway at 280 Cove Road, subject to the conditions we've included in the report here, and they include that the stairway is constructed in accordance with the submitted site plan and schematics, and we note that the stairway and support shall be painted, stained, or anodized with a listed earth tone color. Also, we have a condition that says that the area underneath the stairway shall have breaker run, which is basically a standard for rock or equivalent size rock, installed using stormwater and erosion control best management practices to prevent erosion and heavy storm events. And the intent here is underneath the stairs in the area that's shaded out, that they put some rocks so that they don't have, during rainfalls, they don't have erosion occurring where they can't support vegetation. We also note that all footings supporting the stairway and landing shall be frost protected to a minimum of 3 feet below the ground surface, or utilizing a means acceptable by the state uniform dwelling code. We included this provision just for the board's interest because the stairs aren't, if they were connected to the dwelling, our understanding is the building official for the town of Troy could enforce that requirement, but they're not connected, so we put it in here. It's something that we will be able to enforce because of that. And then I'll note condition number 5, a pre-construction meeting shall be scheduled with staff, and the extent of the area where the vegetation is to be removed shall be flagged, and such areas shall not exceed beyond 1 foot either side of the stairway route, and shall not exceed 8 feet in overall width. It's our understanding that they don't have to do a whole lot of change, nor are they proposing change to the existing grade. So that, again, they shouldn't have to disturb that much vegetation for this, to complete this project. We do note a preference in condition number 6 for a seed mix to plant that limited area that they would disturb. And they could propose an alternative that they could present to me if they're not able to get that seed mix for any reason. It is a Wisconsin DOT referenced seed mix, however, that's good for sloped areas. And also I note that they have the rest of the conditions are our typical conditions we include with conditional use permits, including a timeline for getting the project started and completed. I would note to you also, outside of what we have referenced in our recommendations, that our Corporation Counsel, Heather Amos, has communicated with the Reesers. They had continued to request asking us to forego the double fee requirement, and I see Heather's just arrived. And so Heather has communicated and sort of reinforced staff's position on this. And if you've got any questions about that, you can direct them her way. Otherwise, I'm available for any questions you may have.
I noticed in the drawing of the proposed stairway, it appeared to be a little more of a ramp thing. So my question is, that original one that they'd started without approval had some plateaus in it, or landings, there we go. But if I read that correctly, the regulations say, you know, the way I read it, a number of landings would be permitted as long as none exceed the 50 square foot limit. So I guess my thought is, you know, if that's kind of a ramp thing they're proposing now, and I remember it was for some elderly folks, maybe the landings would be a better option, but that's just my thought. I'm not advocating it.
Yeah, I mean, these are a series of stairs. They're just a little different than what we're used to seeing. They have about a 3-foot run, and between each rise, which is more than what we're used to seeing, but they're still stairs.
Thank you.
Yes, sir.
Are the, is the stair surface permeable, or is it a solid sheet? Or don't we know that yet?
I'm not sure if we know that for certain. I believe the materials, it's constructed out of metal, anodized is what they're proposing, but they're going to have to conform to our color standard, which we obviously referenced in our action.
Yeah, I'm just thinking if it's any kind of expanded metal that's permeable, then obviously runoff underneath the stairs would be an issue, but if it's a solid sheet, then it might change the flavor of the runoff situation.
Yeah, it would seem to me that if it's, as you say, a solid sheet, it will concentrate the runoff, whereas if it's expanded metal, or perforated, it will diffuse it, and the concentrated, I take it that's your point, the concentration of water would make that breaker run rock even more important.
Right.
But it's, in any event, there's the same amount of water to be moved from the atmosphere to the ground, and concentrating it is bad. Spreading it or leaving it the way it falls from the heavens is good, comparatively speaking. But these days, with our bigger rain events and that kind of stuff, it's a real concern about erosion on slopes, and the record indicates here that it's something from 17% on up that we're dealing with here. So it's clearly important to try to keep soil from moving from up to down and ultimately into the river, yeah.
Because these stairs are directed right towards the front of their house, and they're essentially towards their front door, they do have an interest in managing that water, simply because it might become a real nuisance for them if they do not.
That must explain why they've chosen to elevate it off the ground, too. I mean, the stairs that they had at the time we were dealing with the garage issue were right at ground level, you know. It was essentially the kind of thing you'd find at a scout camp or a rustic setting, which would promote infiltration of precipitation quite well, just naturally by itself. Other board members have concerns or questions or anything?
Well, if it's a solid sheet, that'd certainly be a safety problem, and I can't imagine it being a solid sheet of steel on each tread. It'd have to be extruded or perforated or something to give traction.
Or grates
Or grate or something. Yeah, I can't imagine a stairway like that being solid sheet of metal.
Well, they put non-skid materials on those solid sheets to
Yeah,
improve
but
footing.
that scrapes off.
Yeah, oh, there's a maintenance issue with it, there's no doubt about that.
Well, with ice, unless they were heated or something,
Yeah.
But I'm not going to argue it.
yeah.
Mr. Nickum?
Yes, out of curiosity, the double fee. Is that like a fine because they didn't apply for a conditional use permit? And also, is this standard policy?
Yes, so I sent them a long email. So we have a fee schedule that the county board adopts each year. And of course, I can't open it right now. But the fee schedule indicates fees will be doubled for applications submitted after construction has been initiated or written enforcement action has commenced. So the fee schedule says fees will be doubled. And so there's no discretion to the community development department to waive that double fee because it's mandatory in the fee schedule. It doesn't say fees may be doubled, it says fees will be doubled. And in this case, both construction had been initiated prior to approval of a permit and written enforcement action had commenced. So community development did write them a letter indicating, I see you have put up these stairs or temporary stairs prior to being approved by this board. And therefore, you know, your options are to either file an application or it will be referred to Corp Counsel for citations or legal action of some sort. So it's not a fine or forfeiture as defined in the ordinance, but it is a double fee because they did something prior to obtaining approval for it. And so I explained to them that our county board has adopted this schedule and it says will instead of may. If it says may, it would be discretionary. It would allow the community development department to determine when to charge double fees. But there are concerns with that. It's a slippery slope. You know, who do you say you don't have to pay a double fee, but you do? What criteria would be in place? So it's a simpler format to have it mandatory versus discretionary. But that's what I explained to them in the email as to why they're required to pay double fees.
As I indicated earlier, they were provided the option to appeal, but frankly, if they appealed, they would pay the same fee, and then they might be told you're subject to the double fee. So there's probably not a lot of incentive to appeal, but that was an option for them.
Yeah, we've encountered this before. It's not too often, you know, we're dealing with an after-the-fact situation here, as we sometimes call them. And recollect that the standards for an after-the-fact are the same as a before-the-fact. We do not hold it against them in the decision whether or not to grant the conditional use permit. You know, yeah, am I clear about that, or do I need to reiterate that? The law is very clear that when people have been caught in a violation and then they submit their application because they're told they have to have a permission, they have to have a permit, a conditional use permit or a variance, doesn't matter. When it's after the fact, the board applies the very same standards in granting that permit or denying that permit or modifying it, the very same standards as if they had applied before starting their work. Okay, so we close our eyes to the fact that there was a violation when we look at the findings of fact and conclusions of law. All right.
I just think it's kind of interesting, as has been explained, what triggers this. It seems to me this could be a problem with lawsuits, but maybe it's not enough money involved.
The fee schedule, as I understand it, is recommended by the Community Development Committee and is approved by the county board. The basis for the fee schedule is really how much work does it take from staff and what expenses are incurred in publication and other stuff like that. It's not intended to be a money-making scheme. I believe that's a fair statement, Mr. Peterson. It's intended to be a balancing so that the rest of the county's taxpayers aren't bearing the burden of new work going on in the county or violations going on in the county or things like that. That it falls on the people who are applying for something, who are wanting to do something. For them, from their point of view, doing something with their property is entirely voluntary. They can do it or not do it, build stairs or not build stairs. But if they choose to go forward, they need to pay roughly the cost to the county of processing their work. Does that make sense? I believe that's clearly the philosophy behind the fee schedule. And you can see here that Mr. Wozniak had to go out and look at the property. He had to think about it. He had to compare it with the ordinances, look up the fee schedule, write a letter, schedule it for this occasion here today, and so on. All things that would not be normal. It would not happen if they had applied before starting work. And it turned out that the work that they started wouldn't have passed or would have required an exercise of discretion on our part because their landings were too close together, too big on that wooden structure that we have the picture of here. I just wanted to clarify one thing, and I have no idea what your answer will be, but did you meet with either of the Reesers when you were there on October 11th, Mr. Wozniak? Were they there to know that you thought something was wrong?
Yeah, I'm just reminding myself, let me look back at that timeline, because we actually had a meeting with them at our office, and frankly, we told them before.
You went past.
Pardon me.
Yeah, well, I have it open in front of me, and on October 11, you said violation discovered, and October 12, you said letter of violation, and then the letter was served, formally delivered by the sheriff's deputy on October 28th.
They went and built, after the Board of Adjustment meeting, those stairs were constructed without consultation with staff.
Yes, and when you went out there and discovered they had built them, did you see them? Did you tell them this is not right? You're going to need a permit? Or did you not see them that day?
I don't think we saw them. I'm not sure that they were at the property, but it was one of my staff that
it wasn't you
observed
personally.
It wasn't me
somebody else.
personally.
So the letter was sent the next day, drafted and was it both mailed and given to the sheriff for service? Do you do both those things? Or did they never learn that we had an objection until October 28th, when the sheriff's deputy found them at home and gave them the paper?
My recollection is they had, they had traveled to Florida or been in Florida, dealing with some damage to a hurricane-damaged home. I I would have to check our enforcement file on that to confirm if we actually had a face-to-face. I'm sure we communicated with them by email and/or phone. We had a lot of back-and-forth communications with them.
Before October 28th.
Yeah,
Was it before October 12th?
And I can confirm that I was copied on some emails between the staff member and the Reesers. There was a detailed email that was sent by Mrs. Reeser on October 27th at 9:16 a.m. To Jared from Community Development, and there was correspondence going back and forth regarding the violation. So they must have received the letter via mail, and also the sheriff's office served, because this email communication was from October 27th.
I think prior to becoming aware of the violation, our last communication was to provide the decision document for the Board of Adjustment action that occurred on September 22nd.
And I suppose I signed it within a few days, or you signed it for me, or something like that, and then it was put in the mail. Well,
I also know that either Mike or Jared, I'm not sure which, has confirmed several times to me that they talked to the Reesers after the hearing on September 22nd about the fact that they could apply for a conditional use permit for a set of stairs. So they were aware that they needed a conditional use permit for a set of stairs.
and it's in the record from our meeting of September 22nd, isn't it also? Wasn't, I have a vague recollection that it was talked about right here in our meeting, and they were present, of course.
Yes, I believe that's correct. I don't know that it's actually in the minutes, but it would be in the it would be in the recording. yes.
Recording, yeah, okay.
My recollection is the board indicated that you'd be receptive to stairs as an alternative, but it would require a conditional use.
And the sheriff's office did attempt to serve them on October 17th, October 19th, October 22nd, and then finally was able to serve them on October 28th. So I think there was concern that they were out of town. We wanted to make sure they actually received the letter. So that was why we did the dual, both mailing and attempted service.
And then it seems to me there's one other factor, and that is that they have previously approved a conditional use permit for a stairway between the house and the river, on the other side of the house. So they knew about our permitting process for stairways long before this application should have been made. I share your concern. Is it unfair to charge people in an instance like this? And it's my conclusion that it's not in this particular case. Mr.
Is
Tillman.
it even our decision on that here? I don't think we should be discussing the double,
If it's appealed, it'll be back.
yeah, but why discuss it now?
I'm through it, if you are. Very good. There's no one else in the room, so we won't be calling on people to speak to the application for or against, or any of that we normally have in a matter like this. Mr. Wozniak is finished. Board members are finished asking questions. I therefore declare the hearing closed at 9:42, according to the clock on the wall, and am looking for discussion or motion from members of the board.
Well, I'll make the motion, I guess, that we approve the conditional use permit as presented by staff, and I guess I would say provided the resolve of the fee, that they pay what's required.
Thank you, Mr. Peterson, for the motion.
I'll second it.
Mr. Miller seconds the motion. I would note there will need to be that one typo changed in findings 8G. You corrected it, Mike, as you were reading it. Architect showing that the stairway components instead of lift components. It's just a typo there. You'll get it when you.
It's already corrected, and I have the copy right here.
All right, Julie, thank you very much. Any further discussion, board members? All in favor of this motion, which is to essentially adopt as our own the staff's recommendation, of course contingent on the payment of the fee before the actual issuance of the permit. All in favor should vote aye.
Aye.
And opposed should vote nay. It's unanimously approved. Thank you all. Now, we have the Corporation Counsel here at my request, and thank you, Heather, for doing that. I believe that she can give us a little update on pending litigation in which this board is involved. We'll need a motion to go into closed session to discuss with our counsel pending litigation. Moved by Mr. Peterson. Is there a second?
I'll second.
Seconded by Mr. Telejohn. Was it you? Was it Nickum? Yeah. Oh, sorry. Sorry, fellas. He wanted the glory of it, didn't he? Okay, we need a roll call vote. Peterson?
Yes.
Malik, aye.
Miller, aye.
Mr. Telejohn?
Yes.
Yes?
Nickum, yes.
Very good. The motion is passed unanimously. We'll close the doors and Yeah, I do dimly. Just too impatient for this job, which is why one of you should become chairman next time around. During our closed session, we decided it would be a good idea to take some action out here in the open session, and that is to invite representatives of the Public Health Committee and/or the Public Health Nurse Department to attend our next Board of Adjustment meeting, and also to invite the representatives, one or more, of the town of Somerset, and with the intention that those people would be invited into our closed session next month when we are again discussing litigation in which the county is involved. And so, for the sake of convenience, I make that motion.
And I'll second it.
Mr. Miller, thank you. Is there a discussion about it before we vote on it? All right, Mr. Nickum.
Depending on how many applicants for next month, how would you schedule the time for these people to come?
I'd like to work with the staff and probably give that a specified time. And we'll just try to, pick it, if we start at 9, maybe invite them for 10 and try to squeeze in one or two of our regular business first. Do you have your schedule for that day already, Heather?
I already have it on the calendar because I'm
Yeah.
sure about double book. I have it on my calendar for 9 o'clock that day, blocked out till noon, I'll block off.
Well, then maybe, let's see, unfortunately, it's the kind of discussion that could accordion.
In public health staff, we have a flex area here, so they can work until it's time for us to come in here. So it's not a problem. Well, public health staff, like I said, we have a flex area here so they can keep working until it's ready for us to come in here, so.
Yeah.
And
Yeah.
I'll be blocked off and I'll have full staff by that time, so.
Oh. Okay, so we'll work on that. Did I call for the vote? No.
No, not yet.
All in favor, please vote aye.
Aye.
And those opposed, nay. It's unanimously passed. Anything else to discuss about the scheduling of the next meeting or anything like that? You mentioned that it might be a full day, and this makes it even fuller maybe, but there's no reason to set aside 2 days, is there?
No,
All right.
no, we do need this. We can
Anything
just
else?
say that one of the things next month is a lift,
Yeah.
and one is what was the second?
It's another one of these smallish telecommunication sheds.
Telecommunication structure, and then 2 variances. So,
Okay, so possibly the lift and the telecommunication structure would be quite quick.
I expect so.
So maybe in the agenda order, you might list them first and second, and maybe, what do you think? Tentatively put the closed session in the middle there, and the variances after it? We can always adjust the schedule, but by the nature of the thing, when a schedule goes out, the public sort of thinks in terms of the way we've listed it. So
we
I'll
can
work
also
with them.
confirm, we like to confirm with the applicants if they have any conflicts. So
No.
we'll check those things quickly and
Okay.
and then work with you to finalize as suggested.
I should look at my own calendar. Maybe you'll get to preside, Joe. Let's see, that's the 27th? No, I guess I'm going to be here. Yep. Sorry, Joe.
okay.
Unless I get sick.
Well, you're not going to get
I
sick.
can try for it.
No.
All right.
Or another train.
Or another damn train. Former train driver here, you know. Okay, 10:17, I declare us adjourned.